Welcome back to the channel. I am joined today by Vicky Strachan, a chartered patent attorney from the firm Strachan IP, and we are looking at how to defend your patent without going to court. Now, lots of business owners and entrepreneurs are really concerned about the patenting process and the cost of it, and particularly the cost of defending a patent if you end up going down the court process. There's good news, there's lots you can do before it ever gets to that doesn't cost anything like what it might take to go to court. In this video, we're going to explore different strategies that mean that you don't ever have to go down the court route and you can still defend your patent. Over to you, Vicky.
Nobody wants to get involved in lengthy and unpredictable and expensive court proceedings. Nobody wants that. But most lawyers in the profession will tell you that 9 out of 10 patent infringement cases never actually go anywhere near a court, or at least never go anywhere near the final court hearing. The first thing to say is that before anybody goes to court, we have to enter into pre-court communications. We have to send letters before action to the alleged infringer. And these letters before action can say things like, you're infringing our patent and we want you to stop, or we're going to take you to court. And what usually happens is that in response to that letter, there will be a series of communications which will often settle the matter on paper to everybody's satisfaction. And even if you do issue court proceedings, which is the simple part of all that, at that point often settlement communication will happen and it will never end up in court. So that's the first thing to say about court proceedings. It's very rare that they'll go all the way through to the end and can often be settled quite quickly.
So the first thing would be this kind of, am I right in saying it's a cease and desist letter that gets sent, basically saying that you're infringing my patent? Because I guess the person might not even know they're doing it at that point, and that might then spur, as you say, some kind of settlement.
Yeah, in fact, the first letter is often just a notification letter. As you say, they may not even know you have a patent. Yeah. You write to them saying, we have a patent and it's relevant to this product, and quite often even that's enough. Most scrupulous companies will say, oh, we're really sorry, we didn't know you had a patent, we'll stop immediately, or they will try and settle the matter by asking for a license or some time to get rid of existing stock. Yeah. So quite often that simple 2-3 line letter, which isn't going to cost you much in terms of legal expense, that can often be enough.
Okay.
And as you say, cease and desist would be next, and that's quite a formal letter, which says you either stop now and undertake never to do it again, or we're going to take you to court. But even then, that's often accompanied by a without prejudice letter from the solicitor saying, look, we've sent you this formal letter, but actually, if we can settle this quickly off the record, so to speak, which is what without prejudice effectively means, then if we can settle this quickly, then we'll forget all about it, or we'll waive the legal costs or whatever. So to give them an incentive to say, okay, we'll stop and this is how we'll go ahead. So that's often enough,
Okay. And we're talking at this point maybe a few £100, that type of kind of amount of money to get these letters sent? It's not thousands,
No,
is it?
It's not thousands. And quite often your lawyer will have a fixed quote for that sort of letter that will only start to escalate if the cease and desist letter doesn't do what it's supposed to do, or there's lengthy negotiation process to go through. But the costs are manageable, and if there are lengthy negotiation proceedings, you can quite often insist that the other side pays your legal costs as part of the settlement deal. That there are other ways, though, of policing your intellectual property without even going down this sort of legal pre-court proceedings route. Things like customs registration. If you become aware of consignments of infringing products coming into the country from the Far East, for example, what you can do is register your intellectual property with Border Force, and they will then stop these consignments at source from coming into the country.
Wow, okay.
So rather than having to go to individual retailers and try and find out where these infringing products are coming from, you've got a single source, you know who brought it in, and you can take the matter from there.
And again, that's not going to cost tens of thousands of pounds or anything like what it would cost to go to court.
Nothing like it. There is obviously a cost involved, but again, then during the settlement negotiations, you can quite often say, okay, we won't take you to court if you take your consignment back to where it came from and pay our legal costs effectively.
Okay. Yeah. Okay. And I think you've got one other kind of main route that you can go down to try and stop people infringing your patent without court. But just before then, please, if you're finding this video helpful, hit like, hit subscribe. It makes a massive difference to the channel. Thank you.
Yes, now this is really powerful. If an infringer is selling a product on an e-commerce platform like Shopify or Amazon, there is a sort of a process where you can send a notification to Shopify or Amazon saying product X is infringing our intellectual property rights, and they will take the listing down, usually take the listing down until that matter is settled. It's such a powerful way to take an infringing product down, and the process is quite arduous for the infringer in the sense that they either have to prove they're not infringing, or they have to get the person who filed the takedown notice to write to Shopify or Amazon and say, oh, it's okay, we've settled the matter. So it's really powerful.
Yeah, that sounds really good. And I guess it's entirely free for the person with the intellectual property. And also, it's not arduous to report the infringement. As you say, it's arduous for the other person to defend it, but really easy for the person who's reporting it.
Easy and free.
So there you have it, 3 top tips as to how you can defend your patent without ever going to court. Now, maybe you've been persuaded that it's a good idea to get a patent on your idea. Make sure you check out this next video straight away. It goes into all the ways that you can reduce your costs of patenting your idea in the first place. We'll see you there.